to talk with you about two of the frequently asked questions that we hear from the members with respect to the NACVA professional standards, and also let you know where those are located. And we'll answer two commonly frequently asked standards questions from the members and discuss the interpretation of the answers to the two commonly frequently asked questions. And all of the questions, the next slide, all of the questions are posted on the NACVA website. And so I've included the two sites so that you can pull those at any time. And all of the frequently asked questions that are posted have been approved by the EAB. And we're very interested in any feedback from the members. But the purpose of these was just to address some things that we hear asked frequently and try to clarify for the membership. So next slide. So our first frequently asked question that we're going to talk about today is with respect to standards of value. And the question is, are standards of value, such as fair market value, treated the same from state to state relative to matrimonial dissolution litigation, or as we all know, family law? And as you can see, this particular question was approved by the EAB recently in February of 2021. Next slide. So the answer is that it depends. A valuation analyst must work with the client and or the attorney to identify the state-specific terms, definition, and application of the standard of value. What we're really talking about here is both a legal question as well as a professional standards for the valuation industry question. So it's very important that we work with the attorney and identify the state-specific terms, definition, relevant cases, relevant treatises. There are all kinds of sources of information that the attorneys will have in addition to what we have in the valuation industry to address these specific questions. So it's very important in these cases to discuss the specific issue in detail with the attorney. Next slide. So in terms of the interpretation of the answer, standards of value terms such as fair market value, fair value, investment value, and intrinsic value often have nuanced interpretations based upon the jurisdiction and the ligatory, sorry about that, purpose. That's a word I don't use often. Anyway, when we're thinking about family law, fair market value has a number of definitions, whereas we just talked about tax. And with tax, we know that the fair market value is defined very specifically by the IRS in Revenue Ruling 5960. And in that ruling, we know that we're assuming a hypothetical arm's length sale without regard to a specific buyer or seller. Whereas in family law, it's somewhat different. In family law, fair market value is still one of the most commonly used standards of value, but the definition differs from jurisdiction to jurisdiction. The application differs as well. So despite calling it fair market value, some jurisdictions exclude portions of the business enterprise, such as personal goodwill, from the marital property. Also, in assuming the hypothetical transaction, the valuation of a minority interest in the IRS definition should generally be discounted for factors such as the subject equity's lack of control and marketability. However, in family law cases, some jurisdictions do not allow for discounts or deferred taxes for those type of things. So big difference. Also, some jurisdictions assume covenants not to compete in the valuation. Others assume that the covenant to compete, not to compete, can be divisible. Some say no, it can't be divisible. And so it's very important to know exactly how that jurisdiction is dealing with the covenant not to compete, even though it's a fair market value standard in some states. Many states have what we call a fair value standard, and each state has case or statutory law that identifies unique circumstances that depart from the definition. And so, even though the state may define it in terms of fair market value, it's really fair value for purposes of family law in many states. And fair value can mean a proportionate share of the marketable control value of the business interest without regard to discounts for lack of control or lack of marketability. Some states refer to investment value, and this is the value for a specific investor based upon the individual's investment requirements and expectations. This approach eliminates the hypothetical buyer and seller. So it's a big difference. Similar to the investment value is intrinsic value, where value may be defined by a particular jurisdiction as the value of an asset to a specific owner or a prospective owner. And this intrinsic value recognizes that the business owner going through divorce will not be selling the business, and therefore the owner will continue to receive the benefits of ownership into the future. The value of the business may be worth more or less to the owner if it were transferred to a hypothetical purchaser. So depending on how it's defined, it may be higher or lower than fair market value as defined by the IRS. So we have to be very, very careful. So again, state to state differences noted in the application of fair market value. Some states distinguish between enterprise and personal goodwill. Many states do not. And so it's very important to know whether the assets are treated as marital assets or even distinguished at all if it's personal goodwill or enterprise goodwill. So this is a big area of difference, which if we got into all of the factors and family law related to enterprise versus personal goodwill, we could spend many days on that topic alone. So with that, we'll get into the second question. And the second question relates to disputes. And specifically, many members asked, does the litigation reporting exemption apply to engagements that are not in formal litigation, but are contested in dispute or in some form of alternative dispute resolution? And again, this is another recent question that the EAB has recently approved. And the answer is yes, absolutely. The reporting exemption applies to engagement where any type of dispute exists. And so more specifically, for this purpose, dispute engagements can include mediation, arbitration, collaborative, and other forms of agreed dispute settlement arrangements. So then we get into the interpretation. Next slide. So according to Section 5D of the NACVA professional standards, evaluation performed for a matter before a court, an arbitrator, a mediator, or other facilitator, or a matter in governmental or administrative proceeding they're all considered dispute, and they're exempt from the reporting provisions of these standards. So the reporting, next slide, the reporting exemption applies whether the matter proceeds to trial or settles. And the litigation waiver does not, however, relieve the member from complying with the developmental standards and all other standards promulgated by NACFA. So even though you may not need to write a report, you can give an oral opinion, you still need to go through all of the development standards and do all of the research, all of the work required for evaluation under the professional standards. The exemption applies only to the report. And this is also an area where the attorneys are extremely important in the discussion of whether or not a report is required. And if a report is required in that particular jurisdiction, what is the most appropriate report given the question in the case? And so there are a lot of different ways this can be handled. So you just have to remember that regardless, you've got to go through the developmental standards to render an opinion, but you may or may not issue a formal report. And if you do issue a report, what is required to be included in that report, you'll need to discuss with the attorney exactly what's required in that jurisdiction.